Yeah. Let me discuss what I would argue as an addendum to the synthesis of the procedural vulnerabilities that took place in Uganda versus Christopher Onyum in terms of a forensic, call it a forensic analysis of procedural errors that may actually undermine the conviction in terms of what transpired. We are all very vast with the unfortunate event that took place in Gaba, around Gaba Community Church, in light of those toddlers that lost their dear lives. God bless their soul and God protect and strengthen the families. But this argument is for purposes of just giving a forensic analysis in terms of the procedural challenges. So I will move beyond the horror of the Gaba child murder and focus something even more fundamental in law in terms of the procedure. And no doubt that the conviction of Christopher Okello Onyum for the brutal killing of these 4 infants is on the facts understandable, yes. The evidence, no doubt, was extremely overwhelming in light of the CCTV footage, for example, in light of the DNA evidence, for example, but also in light of the eyewitnesses in terms of the testimonies that was provided, and also in light of the digital forensic trials that ensued as we were taken through, and the deliberate preparation for the before the killings, okay, in terms of what had transpired before and then to the events. So very few reasonable people doubt that the accused committed the acts. There's no doubt whatsoever. But the criminal justice is not judged only by whether the right person is actually convicted. It's actually judged by whether the conviction was actually reached through a process that was lawful, constitutional, and procedurally clean. That is the other challenge that we have. So because the rule of law does not ask, did we convict the guilty? It doesn't ask that. It instead asks, did we convict the guilty properly? That is the point. So this is the truest test of civilization, if you want, in terms of this. So I will examine the procedural vulnerabilities that may not prove innocence, but may still challenge legality, call it in light of an appeal, perhaps, if it ensued. And again, I will argue this in the context of parts. And let me begin with part 1. Now, under part 1, the first major vulnerability would be in light of the mental health inquiry and the failure to stay proceedings. And I will have a discussion in that context, but not very different from what my esteemed brother and dear friend, senior counsel, the president of the Law Society, Isaac Chimeze, had reminded me in the pursuance of this particular discourse. Anyway, what happened? So during the defense case, the accused elder brother testified under the oath that Christopher Okello Onyum had previously been admitted to Butabika National Referral Mental Hospital in 2020. And this was not gossip. Yes, so this was sworn testimony from a biological brother with personal knowledge. And that is something that we cannot take away again. So in response, the defense counsel invoked Article 28 of the Constitution, and particularly also Section 46 of the Trial on Indictment Act, and requested that medical experts from Butabika be summoned to verify. And first was whether such admission had actually occurred. And second was whether it actually affected the accused fitness to stand trial. So this was a serious constitutional issue, very serious constitutional issue. And one has to work it well with a pinch of salt. So here lies the dilemma. What did the judge do? We all know that Justice Alice Komuhangi Kahuka dismissed the application as irregular. Her reasons were, amongst others, that the application came late, yes, the accused appeared alert, yes, and he could follow the proceedings. Okay? He consulted with counsel in light of that, and in short, the judge relied on courtroom observation. But that is where the legal problem begins, and this is where the dilemma begins coming in. Okay? And so this is an analysis, a forensic analysis in terms of the challenges now. The question would be why this was legally problematic in light of fitness to stand trial is not determined usually by judicial intuition. Yes, it requires professional psychiatric evaluation. So the question is not whether the accused looks calm. Yes, the question is whether he has the mental capacity to understand proceedings and properly defend himself. Now, that is a medical question, not even a visual one. More importantly, the defense was not raising insanity at the time of the offense. They were raising fitness to stand trial. So these are two completely different legal questions. Okay? Conflating them is a serious legal error. That is very, very important for us. Now, let us go a little bit further. Section 8, subsection 1, creates a mandatory stay. Now, this is the strongest point. When you look at section 8(1) of the Human Rights Enforcement Act 2019, provides that once a constitutional right question arises before a high court, the court shall stay proceedings and determine that issue first. The word is not may. The word is shall. And the English people know that the strongest expression is the word shall. It creates mandatory, not optional. Now, once Article 28 was invoked and the mental fitness became a constitutional issue, the trial should have stopped immediately. Unfortunately, it did not. And the court proceeded. Now, this was not a mere irregularity. This was a statutory violation. Very important in the concept of law. Very important in jurisprudence. Let me now go through what I consider as my part 2. Under my part 2, the second major vulnerability in light of what transpired is the Uganda Law Society application. Yes, we all know that they did make an application. So we want to evaluate how it was handled. What actually happened? Now, this perhaps is the most serious issue in the entire case. The Uganda Law Society filed Human Rights Enforcement Application number 170 of 2026. They challenged the constitutionality of the mobile court itself. Their concern, among others, included violation of the presumption of innocence, denial of an impartial court, executive interference. Now, the president's public direction also informed their concern in a sense that he directed a communal or community trial. And the public scenes were the very scene in terms of the court. The transformation, therefore, became a public theater. These were not frivolous concerns. They were constitutional concerns. Important. Much as the better part of me feels this gentleman did wrong, the law, on the other hand, has questions it is raising. So then something disturbing happened. The representatives of the Uganda Law Society arrived to present the application. Now, according to formal protest records, they were physically blocked from accessing the judge. Allegedly, so we are told. They were stopped by court administration. Allegedly, so we are told. Police allegedly enforced the exclusion. They were threatened, allegedly, with substantive or other issues. They were escorted away, allegedly. The application was never heard, as we know it, perhaps. In fact, the judge never ruled on it. So the final judgment does not mention it at all. It's as if the application never existed. That is deeply troubling. I'll continue reminding our viewers the better and heavier and moral part of me agrees with the judgment. The other part is the question of the law. Because in law, everything matters. Part 3 is my argument in terms of why this is a constitutional crisis in the context of what I have just been presenting before. Listen, my friends. Access to court is a constitutional right. Article 50 of the Constitution guarantees access to court for enforcement of these rights. So if lawyers can be physically blocked from reaching a judge, perhaps whether or not true under police direction, then we are no longer discussing mere procedure. We are actually discussing the possibility of executive interference with judicial independence, however convinced we may be. That strikes at the heart of the constitutional democracy. So no criminal conviction, no matter how justified, should actually survive comfortably under that shadow. Very, very important aspect. Again, my friends, if you look at Section 8, subsection 1, it was violated. Once the Uganda Law Society application was filed, Section 8, subsection 1 was triggered again. The court was legally required to do the following things. Number 1, to stay proceedings immediately. Number 2, to determine the constitutional challenge first. Very, very important, my friends. Unfortunately, neither happened. Now, what happened was the trial continued. What happened was judgment was delivered. Yes? So, the constitutional challenge remained unheard. This creates a jurisdictional problem. Jurisdictional in the sense that because where a court proceeds after jurisdiction has been suspended by statute, the resulting judgment may be attacked as an nullity. And that is where the biggest problem is. Yes? Let me go to part 4 of my discussion. 2 applications in terms of one pattern of procedural disregard. Listen. This, my friends, is where the concern becomes very serious. It is not one mistake. It is two mistakes. Two separate applications. Two separate constitutional questions. That, my friend, is or was, they were both ignored. Let me take you through the first in light of the discussion. Very, very important again to understand, comprehend, and synthesize. The first was the mental health inquiry. And then the second was the Uganda Law Society constitutional challenge. Both required a stay. That's where the problem is. And unfortunately, neither received one. So this creates not just procedural irregularity, but a pattern. Yes, a pattern. And appellate courts pay attention to patterns because patterns suggest structural unfairness. Important for us to comprehend. Let us go to what I consider as my part 5 of our discussion. In light of mobile courts and the rule of law, what do we need, or what ought we have desired to know? Let us be clear. A mobile court is not automatically unconstitutional. No. But mobile courts handling capital offenses require greater safeguards, not fewer. Handling a murder trial at the crime scene with public screens, with national outrage, with presidential pressure, creates an obvious risk in terms of that. Justice must not resemble public punishment. As Lord Hewart famously stated in R versus Success Justices, justice must not only be done, it must be seen to be done. At Gaba, justice may have been done, but many Ugandans did not see justice. They saw pressure, yes, perhaps rightly so. They saw theater, as evident as it was. They saw constitutional discomfort. And perception matters. That was also evident. Because public confidence is usually part of the justice itself. And that is important as well. So, when you are making an analysis, a forensic analysis, all that has to be considered as vital, as important. Let's look at part 6. Will these errors overturn the conviction, perhaps? Can they be looked at as substantial enough to cause an effect or a change of the conviction? My legal assessment in this would be as follows. The conviction is likely safe, but not impregnable. The strongest vulnerability is the Uganda Law Society procedural debacle. Yes? Especially the physical blocking of the access to court, allegedly, if it can be proved. And then the issue of bigger than this accused question. It concerns the integrity of the judiciary itself. However, appellate courts are usually pragmatic. Another word there, beautiful. They will also consider overwhelming evidence of guilt, the lack of direct prejudice to the accused, the aspect of public interest in finality. This makes a complete reversal less likely. The probable outcome, probably, is the Court of Appeal may strongly criticize the procedure. Yes, if the law takes us there, but still uphold the conviction. So unless it takes strict jurisdictional approach to Section 8.1, and that, my friend, is the real battleground. That is the real battleground. So, in terms of what I would consider for purposes of our discussion today, as a final reflection, the case teaches us one unforgettable lesson. Procedure is not a technical inconvenience. Procedure is justice. When courts ignore mandatory legal safeguards because guilt appears obvious, they create a dangerous precedent. Today, it is a man, many may believe he is guilty. Tomorrow, it may be an innocent person. That is why the law protects procedure, even when the public demands speed. Because justice without process is only power wearing a robe. The conviction of Christopher Okello, Onyum, may stand, but the Gaba proceedings will forever carry an asterisk, a reminder that justice may have been done, but not in clean constitutional manner the law demands. And my friend, that matters. Because in law, how we convict is just as important as whom we convict. Ladies and gentlemen, I thank you for your attention. Thank you very much.